Hello, and thank you for coming to the Justice Center of the El Paso County Bar Association. My name is Raquel Hernandez, and I am a family law practitioner. Today, we are going to discuss expert testimony as defined by Colorado Rules of Evidence 702, 703, and 706. We will also discuss the underlying basis of the admission under 401, 402, and 403 of the Colorado Rules of Evidence. Let's first turn to what we call the definition of relevant evidence. Rule 401 provides that relevant evidence has the tendency to make the existence of a fact of consequence to the determination of an action more or less probable than it would be without the evidence. All relevant evidence is admissible unless it's otherwise exempted by the U.S. Constitution, the Colorado State Constitution, the Colorado Rules of Evidence, or by Colorado statute. Evidence which is not relevant is not admissible. Further, Rule 403 provides that the exclusion of relevant evidence on the grounds of prejudice, confusion, or a waste of time. Essentially, that means that relevant evidence may be excluded on the basis of unfair prejudice, confusion of the issues, misleading the jury, undue delay, wasted time, or needless presentation of cumulative evidence. So what this means is that the court has discretion in whether or not certain evidence is going to come in, whether or not someone says, hey, this is relevant evidence. If the court finds that it is something that's going to be confusing to either the court or the jury, particularly the jury, is a lot of times that we see this confusion being used as a reason to exclude relevant evidence. A lot of times in family law, we will see needless presentation of cumulative evidence or undue delay as a reason as to why certain evidence should not come in. So that means that parties will want to be certain that they are filing their witness disclosures, both lay and expert witnesses, as defined in their case management orders. And then also, in addition to that, parties will also want to make sure, too, that any expert testimony has a foundation as to their basis. So that's going to take us back to Rule 702. 702 provides that essentially an expert must possess scientific, technical, or other specialized knowledge that will help the trier of fact determine a fact and issue or otherwise understand the evidence. This does not mean that an expert needs to have a certain degree or certification. It just depends on what they are going to be testifying as to. That will essentially say, hey, do we have the basis to form an expert opinion on this? An expert may be qualified by their knowledge, their skill, their experience, their training, or education. Further, an expert opinion may include the ultimate issue that is to be decided by the court. All expert evidence must be both, of course, relevant and reliable, as we discussed previously. Dalbert is a case that essentially kind of gave a guideline on how to look to expert evidence and whether or not it's going to be scientifically based. And this is particularly helpful in cases that deal with technical matters. So the trial court must determine whether the theory or technique has been or can be tested, has been subject to prior review or publication, has a known or potential error rate, and whether or not it is generally accepted in the scientific community. Do keep in mind that a trial judge is the gatekeeper to these preliminary issues as to whether or not the reasoning or the methodology is scientifically valid and whether the reasoning or methodology may be applied to the facts of their case. For an example of an expert that comes in the form of an appraiser can have different qualifications depending on how an appraisal is received. Are we talking about a comparative market analysis? Are we talking about an appraisal that someone actually went in physically to the home and inspected the property? You'll want to make sure that you provide the basis of this expert's opinion, and then also in terms of making sure that they are reviewing the relevant information and that everything is being essentially taken into consideration that is at issue for the court. This further takes us to Rule 703, which provides that facts or data that's used by those experts needs to be either known before or at the hearing. And the reason that we say or at the hearing is because sometimes the basis of someone's expert opinion may not necessarily come out until later on. But should there be reports that they are relying on, or if there's other information that is pertinent to them, it's important that the other side is presented with this information that the expert is using. Another point to consider is the information, if it's the type that it's reasonably relied on by experts in that particular field. Facts or data that's used by the expert don't need to necessarily be admissible themselves, but that is something to be considered of whether or not it's used in that field. So an expert may testify to the opinion without first testifying to other facts or data unless the court requests otherwise. Further, experts may be required to disclose underlying facts or data on cross-examination. Looking to Rule 706, this is an example of court-appointed experts, and the court may appoint an expert on its own motion or by the motion of the parties. Further, parties may agree to an expert or the court may select. In a court appointment of an expert, we're going to have disclosure of their duties in writing, and those will also be filed with the court. Expert is also entitled to reasonable compensation, and the court may apportion compensation between the parties. Any party may take an expert disposition, and Rule 706 does not limit the party's ability to call their own experts. So when do you call on experts? Essentially, one good answer is to say, hey, this is something that's very important to a particular party or maybe both parties, and this is a matter that's in great dispute. That means that maybe you do want to go ahead and take on the potential additional costs of an expert, and that you would want to take away some time from your lay witness testimony to provide for expert witness testimony. In doing so, it's important to remember to follow the case management orders so that your disclosures of the expert and their underlying data is on time. If not, you may have a situation where you're facing objections to either the report being admitted into evidence or potentially testimony itself being excluded from evidence. Further, another way to kind of figure out if there's going to be a need for a potential expert is also to see how the other side kind of feels on the issue. If the parties are able to agree to a joint expert, that can be helpful in kind of limiting the time that is used on the matter, in the sense that, hey, we're having a third party neutral come into a situation and going to evaluate it and give us either their opinion or their evaluation of the property. And these can be helpful in the sense that the parties will typically split the costs or make agreements about how this expert is to be paid. Otherwise, then we would have a situation where we have essentially competing experts, where each party retains an expert in their own right and would go ahead and pay for that expert subject to potential reallocation. And then from there, essentially the two experts would essentially duel in their testimony through both direct and cross-examination, both the underlying facts, their opinion of the matter, and also any sort of like additional inquiries that may arise during cross-examination. It's important to also consider the time issues that come into this, so that if the parties are knowing that expert testimony is likely needed, it's important to make sure that you are having a hearing that is set accordingly. If your hearing is set for an hour, that typically means that each side is going to get 30 minutes, and it may be difficult to have expert testimony and your own client testify during that time period. So it's important to kind of know well in advance that an expert's coming in, because should you decide to ask for an expert later in the case while it's already set, you're either going to be set to the conforms of that hearing, whatever has been set for, or it may be a means by the other side may object to the appointment of the expert or the expert's testimony should the matter have not been previously disclosed. Otherwise, generally speaking, Whenever you're wanting to present expert testimony, you're wanting to make sure that you prepare the expert in advance so that they are comfortable with the court procedures and that they're also familiar with the ways that they need to testify. Are they going to be testifying via phone? Are they going to be in person? Do you need to subpoena them? All these different things are something to be taken well into consideration before hiring an expert, as these issues coming up down the road can prevent, once again, the testimony from coming in. At the end of the day, a party is able to essentially dictate and figure out how they want to present their case. So it's always up to the party unless the court appoints an expert. So essentially, I always like to say, hey, are we looking at a property here, a marital residence or a commercial residence? Do we need evaluation? Does one party have a general idea and the other say, absolutely not? Or is this a matter of a business valuation where truly one party has no idea as to the valuation? There's different reasons and different ways to bring up experts. And essentially, it's going to be pointing to your case presentation and saying, hey, what evidence do I need the court to see and understand so that they rule in my favor? Or what does the other side going to bring and that I need to be concerned of and potentially have a counter report or a counter proposal on? These are all different things that are able to be alleviated through expert testimony, but at the same time, it's just important to make sure that all the pros and cons are considered when making a decision to have an expert in your case. Be sure to consult with an attorney on making decisions like this before hiring an expert, just to make sure that you are following all the various different procedures. But at the same time, should you decide to go ahead and do this on your own, do make sure that you are closely monitoring your case management order, which will give you the deadlines for the disclosure of witnesses and expert reports. Thank you for watching this presentation. We hope it was useful for you. For more videos on family law, free legal advice, or assistance, please visit the Justice Center's website. Thank you.